Hi, everyone. My name is Barina Majewska with the law firm of Vicente, and I'll be moderating today's discussion. This is episode one of the Financial Poise series, Intellectual Property 101, and we're going to cover a pretty wide range of intellectual property topics today. And then in the future episodes two and three, we'll go deeper into some of them. So today is more of an overview, and then with a deeper dive in episode two and three. Um, we have a wonderful group of panelists today. Alan Grafman from All Media Ventures, Sanjay Prasad from Appleton Luff, and Patrick Richards from Mutualist. You can see all of our names on slide 6 of the slide deck, which you should have, and our full bios are at the end of the slide deck. In the interest of time, and so that we're not infomercialing you, we're not going to tell you more about your panelists today. But if you're interested, please feel free to review all of our bios again at the end of your slide decks. And a quick note on the slide deck, we won't be moving through it like a normal PowerPoint. That slide deck is for you guys to use for your own information. There's good summary info there. But like all Financial Poise webinars, we intend for this talk today to be more of a conversation. So we're not going to be going slide by slide. When I ask one of our panelists a question, I'll sort of skip forward. I'll do my best to skip forward to find the slide that's relevant so that it's up, and then you can sort of track that on your end. But the slides will be less important than what the panelists are saying today. So with that said, keep your slides handy. You'll see which slide I pull up. If it's relevant and interesting to you while you listen, you can pull it up on your end as well. And you can take notes too on your slide deck if that's useful to you. We'd also like to thank our sponsors, the National Law Review and Max Asset. You can read more about them on slides 3 and 4. And one last housekeeping point before we get started. Slide 5 contains our disclaimer. Today, you are not our clients. Even though we are lawyers, you're not our legal clients. We're not acting as your lawyers. So this discussion is intended for general education purposes only. It should not be regarded as legal or financial advice, and you should not proceed without consulting legal or financial professionals for your specific set of facts. So with that, let's get started. Sanjay, let's start with you. Today, as small business owners, you'll often hear, and even as owners of larger businesses, you'll often hear that it's important to protect your intellectual property. Can you help us understand at a very basic level, what is intellectual property?
Sure. So intellectual property, it's commonly, as you mentioned, Marina, it's commonly used term. I mean, in general, it means it's an umbrella term that refers to a group of legal rights of things that people create or invent. And so it's generally considered to include patent, trademark, copyright, and trade secret rights. It can also include other things that can be regarded to be intellectual property. Some people regard it to be data protection that's protected separately in other countries. Each of these forms of intellectual property is different and they serve different purposes. In some countries, people also use the term industrial property, which generally refers to patents and trademarks. But in the US, intellectual property, it's commonly used to refer to a whole bunch of things that refer to things that results of creation or invention.
Great, thank you. And Alan, why for a business owner would intellectual property be important? Just give us sort of a high-level business perspective,
So,
please.
Barina, first I get to tell everyone I am not an attorney. I'm a business guy, and I love starting with that. So, think of if you owned the trademark or the copyright to Spider-Man. If you were fortunate enough to have something like that, you might in your business have intellectual property, which Sanjay just went through. Intellectual property is what a business owner creates that can be protected, that can provide additional protections to a business and can make that business thrive. It often is the difference between success, a competitive edge, the intellectual property that is developed and owned. So it's really important to protect it and understand how to protect it, which we're going to touch on through this panel.
Wonderful, thank you. And Patrick, again, at a high level for this part of the webinar, how can we differentiate between the different forms of IP?
Sure. As Sanjay had said, IP generally covers 4 specific regimes in the US: patents, trademarks, copyrights, and trade secrets. And so each sort of protects a different flavor of creation or inventorship. Patents are the regime that protects technical inventions things that are embodied in products and processes. Um, Trademarks protect the company's branding, the names, the logos, the taglines, things of that nature. Copyrights protect original works of authorship. So it's visual art, recorded music, writings, things of that nature. And then trade secrets cover really any confidential information that has value to the business that you're able to keep as a trade secret. Um, Things like the Coke formula or the Google search algorithm would be good examples of that. Um, it's interesting though, any particular product or service might be covered by more than one regime. It's possible you'll have patents, trademarks, and copyrights and trade secrets all related to a single particular product. Software might, you know, the performance of the software might provide certain functionality that's patented. The code itself is original work of authorship that's copywritten. And when sold to customers or licensed to customers, it's under a specific brand name that would be trademarked. In addition to that, there may be something going behind the scenes in the software in a black box that a user might not be aware of, and that may get trade secret protection.
Thanks, Patrick. I'm actually really glad you touched on that. I know that a lot of my clients have some initial confusion before they talk to a lawyer about how those different layers of IP cover different works. So if we have time at the end, I might ask you or one of our other panelists to chime in with like more examples of that because I know it's like one frequent area of confusion for clients. But for now, let's kind of move on at a high level. And Patrick, we'll stay with you for a second. Can you really briefly touch on how someone would go about transferring each type of IP?
Sure. I mean, every one of these rights, although they're intangible, right? It's intellectual property. Um, they're transferred the same way you would with property. There's assignments that are made. You're going to have keywords in a patent assignment that are different than in a trademark assignment, and so on. But they're pretty standard routine forms that you prepare and sign by the interested parties.
Great, thank you. Sanjay, let's come back to you and let's narrow in a little bit more and talk about patents. So to start with, why do we even have a patent system?
Yeah, so some people may not realize this, but the provisions for the patent system are actually set out in the U.S. Constitution, and similarly for the copyright system. And the reason for having the patent system really is to encourage innovation and innovation by rewarding inventors for disclosing and sharing their inventions. And so, in return for disclosing their invention by way of describing it in a patent, they get a period of exclusivity to exploit their invention. So that's the public policy behind the patent system, is to encourage innovation and invention.
Great, thank you. And Patrick, back to you. What does it take to get a patent? How would someone go about that?
So there's three main criteria when you submit a patent application that you're being examined under. It's got to be the right subject matter first. Then what you submit needs to be new, meaning no one's done this before. And it has to be obvious, meaning it's not an obvious combination or variation of what came before it. Um, to get the patent, you work with a patent attorney or a patent professional that's going to prepare a detailed application that goes to the United States Patent and Trademark Office, call it the USPTO. At the USPTO, the application is assigned to an examiner. That examiner is then going to go through a rigorous review process, examination process, where it's common for there to be multiple rejections of the patent, leading to amendments, leading to arguments through the process, and then eventually, hopefully, the grant of a patent. That process often takes years. It's long and complex. Like I said, the examination is fairly rigorous. But then if successful, you have patent protection, which will, then protect you for 20 years for utility patents, 15 years for design patents. And you have a pretty substantial runway of protection if you're able to successfully navigate the process.
Great, thank you. And Patrick, if I wrote a really good fiction book about an intellectual property lawyer this weekend, would I be able to patent that?
You would not, that would definitely be copyright. And then you would not be able to trademark the title of the book unless it became a series, in which case you could.
Great. Very, very helpful. Again, some really good teasers here of things we'll dive into today or in future episodes as we have time. Alan, let's come back to you. Practically speaking, if I'm a business owner and I want to patent something, how could I find out if my invention was already out there?
So Patrick and Sanjay have touched on a patent is the most legally complex from a business person's perspective. It is not something you want to do on your own. Copyright and trademark and trade secrets, you can perhaps get a grip on, but patent is the most complicated. You really need to have somebody do a search. You might be able to do an initial search, but you really need a service or an attorney to go and see if there is something that is close to what you want to patent, and then follow up in a way that Patrick just outlined.
Great, thank you. And Sanjay, given if I go through the process that Alan just described, how would I obtain a patent pending protection? You're muted, Sanjay, sorry.
Sorry for that. The term patent pending refers to the pending of a patent application. And so when you file a patent application, you can put patent pending on on your products or on your website or what have you. As Patrick and Alan have mentioned, there can be a lengthy process for getting a patent issued, and so the patent pending will inform others while your patent application is going through the process that you do have a patent application pending. There are a few different ways to actually accomplish that. What we've been talking about we're generally talking about a utility patent where you file your patent application to describe your invention in detail, and that ultimately results in a patent. There's also something called a provisional patent application, which is it's really a precursor to a utility application, and that came about when the U.S. changed to a first to file as opposed to a first to invent system. And the provisional patent application, it eliminates the formalities and allows you to file your technical description of what your invention is without complying with all the formalities. And that gives you a filing date, which is called a priority date. And so that's evidence in the US Patent Office that you had your invention as of a certain date. And so when you file your provisional application, you can also use patent pending, the designation patent pending also when your provisional is pending. And we can talk a little bit more about provisional applications later if we have time.
Awesome. Thank you, Sanjay. Patrick, let's go back to you. How much does it cost to get a patent? Is
I
there a
mean,
range?
that's almost an unfair question, but it really depends on a lot of factors. Um, there are simple patent applications, there are more complex patent applications. Um, Sometimes it's the subject matter that makes them simple or complex. Sometimes it's the number of related inventions that sort of fit together that might get submitted in an application. On the low end of the scale, you might get a patent application on file for $5,000 to $10,000. More typically, it might be in the $15,000 range. Some more lengthy, complex, technically challenging patents could be $20,000 or more to prepare and file the application. Then there's that lengthy examination process that we discussed, where it's highly variable. You may submit it, and the patent office may say, "Great, it's patentable," and there's a couple $1,000s, and you're done. Or you may have a series of rejections and arguments that go on for years, in which case you spend tens of thousands of dollars with those arguments. Um, and then, of course, you're looking at, are we patenting this just in the US or are we going international as well? Each additional country that you file into is going to be additional expenses. So on the lowest end of the scale, you might go start to finish on a simple mechanical invention and patent it in the US and be done in $10,000 to $15,000. Or you might have a more complex, let's say it's a pharmaceutical, and you're patenting it in a dozen countries. You're going to be well into the six figures by the time you're done.
Thank you. And Sanjay, we heard a bit from Patrick about some of the things that can affect the costs of getting a patent. Can you speak a little bit more generally about how long it takes to get a patent? Probably another
Yeah,
unfair question.
and Patrick did a good job of kind of setting out some of the complexities of the patent system. In general, it'll generally take you about 2 to 3 years to get a patent, but that's just a general rule of thumb. You can actually get a patent in less than a year if you expedite prosecution. Or it can take quite a bit longer than 3 years, 5 years, 7 years, a decade for some more, if the prosecution gets particularly complex. And also, if as an applicant, if you want to be particularly aggressive in the scope that you're trying to get for your patent. So it can take longer, but 2 to 3 years is generally a rule of thumb to consider. It can be shorter if you're willing to be less aggressive in terms of what you're claiming as an invention, and if you've done a lot of the upfront work in terms of um, searching and clearly defining your invention, or in some fields like software, other computer-related applications, life sciences, which are much more complex, it can take a lot longer.
Great. And Patrick, back to you. We've heard a little bit about the headaches, length of time, and costs of getting a patent. So why would I want to get one? What does having a patent allow me to do?
Well, that's where the fun begins. This is where you get to stop others from making, using, selling whatever it is that's been protected. And in the US, it's making, using, selling, offering to sell, or importing into the country. So it really is a borders in protection for that particular patent. Um, the difficulty with that is you, the patent owner, are the enforcer. No one's going to come in and enforce your rights. So if someone is copying you, if someone's infringing on your rights, it's on you to whether it's a cease and desist letter that you're able to negotiate them to refrain, or filing a lawsuit and taking that through to challenge their use. That's something that is on the patent owner.
Great, thank you. And Sanjay, one last sort of technical question on patents for now. Once I have a patent, how long does it last?
It lasts from 20 years from when your application was filed. So if you assume it'll take you generally 2 to 3 years from filing to issuance, you'll get roughly 17 years from in terms of term on your patent. And that is now, we've been focusing on the US. The US conformed to really the worldwide system, which is 20 years from filing. And so that's around the world nowadays. Assuming that you get patents in other countries, they're national rights.
Great, thank you. And we're going to let go of patent here, I think, and move on to trademark. But before we get into what exactly is a trademark, Patrick, I wonder if you can talk sort of very briefly, high level, what is the difference between a patent and a trademark? And I'm going to ask these kind of annoying questions every time we switch from one type of IP to another so that our listeners who don't know can start to get a felt sense of how these different types of IP work and where they overlap and where they don't.
Yeah, I mean, I think these are the best questions because um, it's not uncommon for a client to call me up and say, I've got a copyright question. Can you help me patent this trademark? And I mean, and that's not uncommon. And I'm not even mocking the person. I've heard that multiple times. Patents protect the inventions, the products or the processes, the inventions themselves. Trademarks protect the branding, how that is presented to the consumers, what the name is, the logo. So you can have a product, right? I grab my phone. I've got an iPhone here, right? There are patents on the physical mechanisms of that phone, the display, its communication systems, its antennas, all of those things have patents. And then the trademark is the name and the logo that goes on it.
Great, thank you. I love the phone example. So, like, this is not a chunk of intellectual property, of a single type of intellectual property, right? It's multi-layers of types of intellectual property working together.
There are patents and trademarks and copyrights and trade secrets in that phone, and there are probably hundreds of them.
Great. I love the concreteness of that. Thank you. Okay, let's leave patents and move on to trademarks. Alan, will you introduce us to trademarks? Why are trademarks important for a business person?
So I'm going to expand it a little bit because it's possible that if you took 100 businesses, patents would relate to perhaps the smallest group, copyrights, maybe the next size. Trademarks are relevant for almost every business. Almost every business can have a trademark on something that is distinctive and removes confusion from the market so that their products can be clearly identified and sold as distinctive. If you read papers, you will often see there are contests where a trademark owner will enforce a trademark against something that they believe confuses the market. And an example of that might be where Reese's has a trademark, I believe, check me on this, on the color and packaging. So there's no confusion as to the candy. So to follow up on Patrick's point, trademarks are intended to remove confusion from the market so that buyers of goods get what they are expecting and are not diverted to goods that are not what they're expecting.
Very helpful. Can we sort of stay on that? I might be asking you to repeat yourself a little bit, but can you give me some more examples of trademarks?
Sure. By the way, Patrick mentioned, if I'm not mistaken, I think Apple has certain trademarks on shapes, on some of its products, shapes, colors, presentations. You can go through, the ones that are here, which are known to everyone. Apple, by the way, interestingly, had to resolve a contest decades ago with Apple Records, where there was a contest between the Beatles label, Apple Records, and they had a little bit of an imbroglio, a little bit of a wrestling match. You see a lot of elements here. Kleenex also had a big contest, and Kleenex may have even, I don't think it did, it had a perilous route to almost becoming a generic name. So you see examples here which are self-evident. Every business owner can look at products on the shelf or products they buy, and they'll often see this circle R that we see.
Yeah, and you touched on something interesting. Maybe we won't dive into it, but we'll add it to an interesting list of topics to cover at the end of today if we have time, or in a future episode if we don't. But this idea of what becomes a generic trademark, and what you lose as a business owner if that happens to your trademark. So maybe I'll just flag that for something we'll cover at the end of today if we have time. Sanjay, let's stick with some more technicalities and basics. Can someone trademark something other than a word or a slogan?
Yeah, the answer is yes. As Patrick and Alan have mentioned, the a trademark identifies the source of goods, and so that can be much broader than a word or slogan, which is what we typically tend to think of as a trademark. So, for example, if if there is a something else like a sound or a color or smell that consumers would associate with the source of goods, that can also be trademarked. And an example of a sound would be the NBC chimes associated with NBC radio and television programming. Example of color would be the color pink by Owens Corning. I don't know of an actual example of a smell offhand. Another example of sound would be when we drive down the road and we hear a loud motorcycle. Oftentimes that's a Harley Davidson. And I know they've at least tried to trademark that. I'm not sure if they were successful in it, but that would be again an association with the source of goods.
I know
And
there's
I
been a
want to
growth.
jump in, Farina.
Please go ahead, Alan.
Years ago, NBC wanted a big red N as their logo. And unfortunately, Nebraska had that, I believe, trademarked. And there again, there was a fist fight over, and I don't recall who bought who off or who negotiated. But you will see these types of contests regularly in business press. And that one goes back quite a ways. And as far as a smell, colors have been trademarked. I can't think of a smell. There might be one. Maybe that's another topic for another day.
Yeah, I know there's a growing market in like smells of luxury hotels.
Yes,
And I'm wondering if those are trademarked. It's not something I've worked
they
with
are.
personally. They are. Good to
Yeah.
know.
Yeah.
Yeah, very interesting. I know that's like a growing market, so that's interesting. All right, Patrick, let's come back to you. So we've learned we can register trademarks. What are some of the legal advantages to registration?
Sure. When you are using a source identifier, a name, a logo, whatever it might be, with customers, you are naturally acquiring common law trademark rights, but those rights are limited in scope. It's where you're using it, where those customers are located, and it really is a highly fact dependent, this is what you've gotten because this is how you've used it. Filing a federal registration for a trademark, and there are state registrations as well, but filing a federal registration gives you nationwide rights. And it gives you a lot of presumptions about that it's being used in all 50 states. You don't have to prove you've got a customer in Alaska. It's, these things just become part of the bundle of rights that you get. Um, and there's a lot of statutory requirements that get met that make it easier to enforce your rights against third parties when you have it registered. If I go into a courtroom with an unregistered trademark, I may have the same successful outcome, but it's my burden to prove a number of things at court if it's not registered. Whereas if it is registered, it's the defendant's burden to disprove a number of things that are assumed to be true. It also, lets you use the circle R, as was discussed earlier, next to the name to show that it's a registered mark. Um, Gives you rights to file in other countries, claiming back to the rights in the US. It allows you to stop counterfeit goods coming through customs. There's a number of sort of ancillary benefits of that federal registration. And unlike patents, it's not nearly as uh, costly or time consuming.
Owners. Yeah. Okay, that's great, Patrick. And Sanjay, Patrick gave us some of the legal advantages to registration. Can you maybe flesh out some more of these non-legal or qualitative advantages to registration that we may not have covered so far?
Sure, there's a very practical one. Patrick laid out kind of some of the steps that you need to go through to get a trademark, and one of those is what typically happens is before a company will file for trademark registration. Typically, they'll do a search, and on that search, the what will come up is prior applications or registrations that are similar to what's being sought to be registered, and so if you turn that around, if you actually file for trademark registration, a big benefit is that others, when they see your application, they will know that it's there. And then typically, not all the time, but typically there is an effort to avoid that. And so you get a very practical consequence of reducing overlap by filing your own application because it then becomes easily known to others. And so that deters later comers from adopting a similar mark. And so that helps to preserve and promote the value of your own mark. And there's a real practical impact in that it reduces expensive and time-consuming disputes and litigation. But also, when you get that registration, being able to add that R with the circle around it to your mark, it gives you greater credibility to your use of the mark, and greater impression of legitimacy to competitors, courts, and juries.
Great, thank you. I think in the interest of moving along, we're going to leave trademark for now. There's a couple interesting questions that came up in your answers that we might want to hit on if we have time. So let's pause on that and move on to copyright. Alan, can you tell us a little bit about copyright and why someone might want a copyright?
Well, I can tell you a lot, but I'm going to tell you a little because copyright is where I spend most of my time. So, copyright for creative endeavors, which are largely written, music, depiction, dramatic, or sometimes art, those rights you get for automatically, but you can protect them more. They give you rights to reproduce, they give you rights to license, they give you rights to perform, they give you rights to collect funds. Copyright is most prevalent in the intellectual property creative areas, as you just heard. It is something that we don't touch on music here on this program, but there are multiple ways that people protect. Writers who write original works will often file it before they're even able to monetize it. So copyright for people who are in the creative sectors is their way of protecting their creativity. And in fact, if you look in books now, You will see that books are now putting that the book cannot be used to train AI. That's perhaps on the forward tip of the spear. So it's really important, and people who are in the creative arts know how to protect. But for business owners, if you're creating original material that's creative, you will want to know how to protect. And basically, once it's created, it's protected, but you will want to register it to protect it even further for the reasons that you've heard untouched in other sectors.
Great. A couple more interesting questions came up from what you said. I'm just jotting them down. Sanjay, let's keep moving along with the basics of copyright. What kinds of things can be protected under copyright law?
Yeah, so Alan kind of nicely characterized copyright as protecting results of creative endeavors. And so that comes out a number of ways. So under the Copyright Act, it talks about works of authorship, and that includes and protection of works of authorship, which includes literary, dramatic, musical, and artistic works. And so that would include, for example, things like poetry, novels, movies, songs. It also includes computer software and architecture. And in general, the term author is used very broadly in the Copyright Act, and that includes writers, composers, visual artists, choreographers, filmmakers, architects, musicians, computer software programmers. They're all deemed to be engaging in the field of creative endeavors. Um, there's an important thing to remember about copyright law is that there is an important limitation, and that is that copyright doesn't protect facts or ideas or systems or methods of operation, but it can protect the way those things are expressed. So, practical example of that is you can't, as an author, copyright the general idea for a story, but assuming it's sufficiently original, you can copyright the written story itself. So the collection of all the written words you can copyright, but the general idea. So this is kind of a rich field. There's all sorts of really interesting cases around cartoon characters and Superman and so forth, and whether later similar books or movies infringe earlier copyrights on those, and then there's analysis as to what the similarities and differences are, and what's the idea, and what's the expression, and so forth. But just important to keep in mind that generally, more abstract things like facts and ideas and systems or methods of operations cannot be copyrighted.
Great. And Sanjay, just to pick that piece out, systems or methods of operation in particular, what would we look to try to protect that if we couldn't use copyright?
So you could use copyright for the protectable expression in there. So, for example, computer software, the code is copyrightable, but the systems or methods embodied in that code is not copyrightable. That may be protectable by patents, maybe also by trade secrets. Similarly, for architectural works, the idea of a house cannot be copyrighted, but the specific design of the house can be copyrighted.
Great, thank you. I think we're really starting to flesh out sort of how these different categories overlap with each other. Ellen, let's go back to you. Say I have an idea in my head, and moreover, it's a very original idea. It's an idea no one has ever thought of before. Is it automatically copyrighted?
No, it's not automatically copyrighted, and a lot of great ideas in the shower never get copyrighted upon the reflection of day. In order to get full protection, it has to be expressed in a concrete form, and it can be a dramatic work, it can be a written work, it can be a work of art. It has to have it has to have a specific format that can be copyrighted. And Sanjay touched on something I want to expand again very briefly. So first, the Copyright Act was extended. It's sometimes called the Disney Act, where the protection was extended an additional significant amount of years. Secondly, whether something is copyrighted and protecting your expression will often be the focus of a lot of conflict. So for instance, I was president of Archie Comics. There was a little bit of to do whether the Archie that was copyrighted 50 years ago was the same one that was out and about in today's world. And even recently, there was a wrestling match around the Top Gun sequel that was just resolved whether the rights that had been granted based on a published work that were in a contract that led to a sequel, whether those initial works were copyrighted and provided full protection or not. So copyright, again, you will see in the news often, and we've touched on some of the factors that go around that protection.
Great. Thanks, Alan. Patrick, back to you. Once that, if I do have copyright in something, what does that copyright allow me to do?
And Alan had touched on this earlier. When we talk about copyrights, we as professionals often talk about them as a bundle of rights because the copyrights to a single work of art include things like the performance rights and the distribution rights and all sorts of related but separable rights. So as the owner of a copyright registration, you're able to sell or license or maintain exclusive ownership of each of those sort of independent sticks within that bundle of rights. Um, and it just gives you the flexibility and sort of the framework and structure to parse out, here's an author and they get, this portion of it. This is a performer, they get that portion of it. This is a label or a distribution company or whatever it might be, and they get this portion, all related to a singular work.
Great. And just because it's on the slide and it's on my mind, do I have to register to have copyright protection?
So you don't have to register, as was said earlier. The moment that an original work of authorship is fixed in tangible media, you've got copyright protection. So I'm a musician. I could sing you a song today. I'm not a good singer. You wouldn't want to hear it. But if I just wrote a song from memory, sang it to you, no copyright protection. But if I write those lyrics on a piece of paper, copyright protection. If we
Fantastic.
record the video or the audio of me performing, copyright protection. And then you can go and register those elements that have that copyright protection.
Fantastic. So we're kind of picking out this concept of expression that Alan introduced us to a couple questions ago, and then the separate concept of registration, which I think we might want to talk a bit more about. But Sanjay, let me come back to you for a minute and ask. We talked a little bit about copyright versus patent in the software example earlier you gave. How about trademark? How is copyright different from a trademark?
Yeah, so a trademark, I think Alan and Patrick have done a nice job of explaining that. I mean, trademark identifies the source of a good. And so let me just kind of use an example to kind of differentiate the three. And so, for example, if you have if you're a musician and maybe you invent a new type of a musical instrument, and so you seek patent protection on that. And if you use that musical instrument to create a new song that you write, that song may be protectable by copyright, and you may wish to trademark your band's name, or if you design to go into the music business and have a music label, you could use trademark to protect your music label's name. And so you've got the three different types of protection that protect kind of distinct areas of your creative endeavors and of your business.
Okay, great. And we learned from Patrick a moment ago that we don't have to register a copyright. Why would we? Sanjay, sorry.
Oh, yes, I'm sorry. Yeah, so to register a copyright, so so it's not required, but there are some benefits. And so I think Alan mentioned that, that you don't, you get copyright protection from the moment that you put it down on a tangible medium, you write it down, you type it in, what have you, you draw it out. But registration gives you a number of benefits. It creates a public record, and so others are notified of of your claim to a copyright for that particular work. And so for those who may want to license your work, they can actually determine the status and reach out to try and get a license. The other one is that registration, it's required to enforce your right in federal court. And so if you before you file a lawsuit in federal court, you will have to register your copyright if you haven't done so earlier. And it's also evidence that your copyright is valid. So filing your registration within 5 years of your work, that'll help in the event that you need to bring an infringement suit in court. And so that's a procedural benefit. It satisfies the basic level of proof that your copyright is valid. It doesn't mean that your claim is guaranteed, but it does provide you that procedural benefit. It gives you a stronger position in court. And then finally, in a number of areas, it's either difficult or expensive to establish damages. And so registration enables you to claim what are called statutory damages. They're damages set out in the Copyright Act, and also attorney's fees. And so that's got a requirement. You need to file your registration within 3 months of publication or at any time prior to an infringement. That allow you to recover statutory damages and attorney's fees.
Thank you, Sanjay. Alan, let's come back to you. This phrase "work made for hire" ends up being really important in the field of copyright. What does that mean?
So work made for hire, it means you don't own it. Somebody hired you, put it in the contract that what you were doing was for hire, and they've paid you in some fashion, and you do not own it. In years past, it was a source of tremendous controversy. The creators of Superman essentially, I won't say died penniless, but did not enjoy the fruits of their huge success. And the industry took up an effort to compensate them. Same thing with Stan Lee. He essentially similarly had the same force against him that he had to combat. So anyone in the industry, anyone creating, or any business, to cover from both sides, will want to make absolutely certain to understand, are they the owner of what they're creating, which is possible, or are they being hired and making a work for hire?
Great. Thank you. And there are obviously ways, again, I don't know that we have time here, right, but to modify whether some work is created as a work made for hire or not. And there's ways that parties can negotiate around that. Maybe I'll jot that down as a topic for the end. We're coming up at our last 15 minutes here. Patrick, let's keep moving sort of with the basics of copyright law. How long does copyright protection last?
So under the current rules, any original work created January 1st, 1978 or later lasts the entire length of the author's life plus 70 years after their death. Now, there's other types of works, the work for hires we were just discussing, anonymous works, works made, on behalf of a corporation. Those get a different length of time. They're either the shorter of 95 years from publication or 120 years from their creation.
Great, thank you. And Patrick, let's stay with you for a minute. Can you talk, I know this is a big question, but can you talk a bit about how IP law in general intersects with corporate and employment law? This question of work made for hire really implicates some of the employment law issues. So can you talk sort of generally about that?
Yes, of course. And so this tends to be a lot of state law related intermingling issues where, the state that governs the LLC or the corporation, the state that governs the employment law context, those all have some influence. But generally speaking, all three of these areas come together when you're trying to figure out who owns what. And it's often, let's say you've got a startup company, the founders might invent some technology, start working on that, decide this looks promising, form an LLC, and now they need to assign their rights from their individual ownership to that sort of business entity in order for third-party investors to invest in that entity, right? The LLC doesn't own it until the inventors assign it to the business. So it's really important in all these contexts, corporate law contexts, employment law contexts, to have appropriate documentation, to have appropriate agreements. Your employment agreements with your employees should dictate who owns the intellectual property that's created in the course of business. Same with your independent contractors. Hey, we're hiring you as a work for hire. What you're creating, we're going to own, or maybe not. We're going to license what you create and you own it, and we use it non-exclusively, but you can use it with others. So that means we don't have to pay you as much. There's ways that all of these issues can be handled, but it's really important to have very clear contractual agreements, particularly at the end of the road when you're looking to sell a business, you're looking to, sell some of the assets. Any of the buyers is going to want to look back and see a clear chain of title. Did the company own this asset? Does it comply with the corporate rules? Does it comply with the employment law rules? Were there appropriate IP assignments filed? All of those things come together, and that obviously could be an hour-long talk itself, but it's important at all stages to be thinking about properly documenting who owns what rights at what point in time.
Verena,
Yeah,
I want to jump in because
please.
Patrick, someone could take the misimpression. It's not so much at the end of the process. It's equally important at the beginning of the process because in any transaction, both are important. I'm going to simply suggest that at the beginning, it's critical that there be clarity on this issue so that at the end of the process, where Patrick was referring, it's got to be clear for any transaction, any capital transaction, or any sale. It is possible to go all the way back and track that it was super clear at the beginning. Very often, businesses will deal with this in a way that isn't clear enough for a third party to be 100% certain. And so my point is for business owners that have records that aren't current, don't have meeting notes, don't have clear transfer of interest, have divorces and children and all those things, those need to be clear before you try to raise money or before you try to have a process, because otherwise you're going to get gummed up in very expensive. And that's not the time to negotiate when you have somebody who wants to invest in your business. So in addition to Patrick, where it's got to be clean at the end and clear, it needs to be clear really all the way through. And if not, it deserves attention.
Selling your company is a fantastic way to find out where you messed up on your IP and tracking it and documenting
Yeah,
it. It's
yeah,
it's
yeah,
it's
we're
like the
trying.
final exam.
Yes.
Okay, great. Thank you guys. In the interest of, moving this along, I'm going to keep going. We've covered patents, we've covered trademarks, we've covered copyrights. Let's move on to trade secrets. And Alan, let's stay with you. What's a trade secret, and why, as a business owner, might I care about trade secrets?
Okay, so trade secrets are perhaps the broadest relevant category of intellectual property. It is possible that everyone on this call, every business, has trade secrets, and it varies by state. But a trade secret is information or a process or a formula, a process, or information that is distinctive and gives a business an advantage in the marketplace. It is something that a business needs to protect, and we'll get into that in a little bit later. But it can be marketing lists. It can be people that you do business with or have relationships with. It can be manufacturing processes. It can be formulas, which we've talked about. Trade secrets are a business advantage that need to be protected, and we'll come to that in a moment.
Great, thank you. Sanjay, do I have to register a trade secret?
The short answer is no, but it goes beyond that. Not only do you not have to, you can't register a trade secret. And so, we talked about patents where you can't get a patent until you make a filing with the government. And we talked about copyrights where you get the rights upon putting it on physical medium, but there's a benefit in registration. And trademarks is similar. You don't need to register to get the benefit, but there are benefits to register. With trade secrets, there's no mechanism to register, and in fact, If you were to actually describe your trade secret and say, I have a secret on it, that's self-defeating. That would destroy its confidential nature. And so um, uh, obtaining a trade secret is entirely a private act that you need to do on your own without with any filings with the government.
I think you said that really well, and I would just want to underline that again for the audience that trade secret, in a way, operates exactly the inverse of how patent operates. You're not rewarded for your disclosure, and that's really important for folks to understand. You
Mhm.
don't want to disclose it. You don't want to file it openly. You don't want to make it public to others to gain some sort of protection. It works the exact opposite. That will destroy your protection in trade secret. So yeah, I think you said that really well, and I just wanted to underline that for our listeners. Patrick, let's move to you. How would a court determine that something is a trade secret? What legal factors would they look at?
As Alan and Sanjay have sort of explained, a trade secret is any confidential information that has economic value, right? It's that simple. But the way that you determine, is it confidential and does it have economic value? There's a bunch of factors, right? Who knows or has access to this information outside of the business? Who inside of the business has access to it? Is it limited to select employees, or is it just on a drive that's accessible to anyone? Um, what steps the owner has taken to keep it confidential, the value to the business in keeping it confidential, right? Is it clear a competitor pays more for our product because there's some secret formula that the market believes is more valuable than what else is out there? The amount of effort that you've made, the amount of time, money, expense you've invested in keeping it secret, and then also how much effort it would take for a third party to recreate or reverse engineer whatever it is that's secret. It could be the fact that something's secret, but if you stuck three people in a room and you gave them, 3 days, they'd figure it out. And it could be that you could stick 100 people in a room for 3 years and they couldn't figure it out. And that's going to weigh into whether something's a trade secret or not.
Great, thank you. Sanjay, back to you. Does the federal government recognize trade secret protection, or is this just a state affair?
The federal government does, and that's a relatively recent thing. Historically, in the US, trade secret protection was entirely a creation of state law. And most states, most if not all, have signed on to the Uniform Trade Secrets Act. And so the definition of a trade secret in most states is largely similar. Relatively recently, there's been federal legislation that's passed, which gives you a federal remedy, which allows you to sue in federal court for a civil violation for trade secret theft. In addition, you now have, with that same law, you have criminal penalties also for trade secret theft, and so it can be a crime for a federal employee to knowingly disclose the trade secrets of a party. You can have enforcement, and we've seen a few relatively high profile examples of enforcement by the U.S. Department of Justice for trade secret theft. And so you now have kind of this overlapping ability to enforce your trade secret not only under state law but also under federal law.
Thank you. Alan, back to you. Practically speaking, can I prevent my employees from disclosing my trade secrets, thereby ruining their secretive nature?
Yes, and it's important to differentiate that from non-competes. Non-competes, which you haven't asked about, but non-competes are under siege. They're very hard to enforce. And that is one technique that businesses will sometimes try to limit people from going to competitors. Trade secrets, though, are, as Sanjay just outlined, trade secrets are protectable. We've listed some of the ways, in fact, right here on this slide, to protect it. It is often protected in employment agreements, most specifically, employment agreements where there is very clear delineation, sometimes broadly, regarding trade secrets, and sometimes very specifically trade secrets in a particular area that is germane and limited to that person's activity. So for instance, on a marketing executive might be very clearly in an employment agreement have access to marketing materials or customer lists and pricing lists. And that's really important to the business. and that can be delineated on a non-disclosure, an employment agreement, and a non-compete. The non-compete, as I said, is hard to enforce, but the non-disclosure of trade secrets is very much something that can be enforced, sometimes with difficulty.
Could you tell us what a non-disclosure agreement is generally?
Well, sure. So a non-disclosure agreement relates to, and you do see these in the news often. A non-disclosure agreement is such that an employee, on terms of their employment, and now almost every employee signs, a general release or a general agreement. They are not, they are forbidden, not only not allowed, but they are forbidden to disclose material aspects of the business and their employment. So they are not able to disclose to really, often depending on how it's defined, they're not able to disclose the particulars of their employment, and in specific trade secrets that are sometimes defined and sometimes very broadly outlined.
Great. Thank you. And then Sanjay, let's go back to you and go back to this theme of trying to understand the different types of intellectual property and how their protections can interact and overlap. How would I decide whether to patent something, which would create this disclosure that we talked about, or to keep it as a trade secret, which would prevent me from having any kind of disclosure in order to get its protection?
Yeah, good question. So the important thing to remember is that for patents, there are limitations of what you can patent, right? So first of all, it in terms of subject matter, things like business information is not patentable. And once you get into some areas of software and some areas of life sciences, sometimes those are not patentable either. And so in terms of subject matter, if it's outside the subject matter, what can be patented, you wouldn't be able to patent it. And so maybe it's something you can keep it as a trade secret. But if it's within that scope of subject matter, you'll then need to decide, first of all, is it patentable? Does it reach the level of patentability? And if you have some question around that, maybe you want to keep that as a trade secret. Also, some things will eventually be disclosed. If it's something that's if it's something with respect to a product that you're going to be selling, and once you start selling that, it'll be visible. That will no longer be a trade secret. So you'll want to be able to patent that, right? Because you won't be able to keep it as a trade secret. Also, for things that may change relatively quickly, patent protection takes a long time, and so you won't want to patent that simply because of the expense. You could keep that as a trade secret, although maybe it won't last very long. And finally, if it's the type of thing that will not be discernible. I kind of touched upon this earlier, but will not be discernible by others, either in a product or whether it's kept within the four walls of your business. That's something you could keep as a trade secret also. And again, the common examples of that are the recipe for Kentucky Fried Chicken or for Coca-Cola. They've been kept trade secrets for decades, maybe close to a century, and they still provide business advantage. Whereas if there had been a patent on that, that would have been publicly known a long time ago.
And if I
Great.
could jump in real quickly, you will see often reverse engineering. And to Sanjay's point, processes in like manufacturing processes that provide a distinctive business advantage may be best protected as a trade secret because that's going to be harder to reverse engineer. Whereas if it's filed as a patent, it's going to be easy for you know who. Starts with a C, H, and you can go from there to steal. There are enormous amounts of intellectual property theft that are going on, and a lot of it starts with looking at the patent and then going from there. So as Sanjay just touched on, sometimes keeping a process uh, as a trade secret rather than trying to obtain a patent, which might not be successful, by the way, after having been disclosed. So something to be aware of.
Great. Thank you, Alan. And Patrick, let's wrap it up with you with the same question we've asked for each of these types. How long does trade secret protection last?
As long as you can keep it secret. There's no expiration, and that's why Alan was explaining what NDAs are and why they're very important, and why it's important for businesses to actively, proactively take steps to limit access to that information, to show that they are treating it as their confidential trade secret, Because if they're doing that, we're never going to find out what the Coke formula is. We're never going to have access to these trade secrets that have value to those brands. The all important trademark, which is really, if you ask me, the most valuable of all of these, the patents, the copyrights, the trade secrets, those protect the elements of the business that build its reputation in the marketplace, which is what the trademark represents. And I think all of this other IP stands to support the value of, what your business is, what that brand is.
Okay. Great, thank you. And thank you, all of you. It's 2 o'clock, so we're just a minute over our allotted time for the day. We did not get back to any of these kind of fun, niche, and interesting questions that arose as we were talking about it, but I hope our listeners will join us for episodes 2 and 3, where we will have some more time for the nitty-gritty of these topics. But thank you all so much. I think this was a lovely conversation, and we hope you guys learned a lot.
Thank you very much.
Thank
Thank you,
you.
Brina.
Thanks, everyone. Take care.
Bye-bye.